From the opinion pages of the Wall Street Journal, this is Potomac Watch.
A federal appeals court upholds a core part of an injunction against government pressure on social media sites as the governor of New Mexico signs an order purporting to ban the carrying of guns for 30 days. Welcome, I'm Kyle Peterson with the Wall Street Journal. We are joined today by my colleagues, columnists Alicia Finley and Kim Strassel. The Fifth Circuit Court of Appeals ruled Friday in a case called Missouri v. Biden. This is a case involving the pressure that the Biden administration purportedly put on social media sites to censor content, particularly during COVID-19. There had been an injunction issued at the lower court of the district court level by Judge Terry Doughty. And Alicia, you've looked in detail at this Fifth Circuit ruling. What does it say? What pieces of the injunction are upheld and what pieces are thrown out?
In ways, it basically reaffirms the Judge Doughty's opinion back in July that the government, and actually some of this stuff goes back to the Trump administration. Most of it occurred during the Biden administration, but there were some evidence that there was actually coordination occurring with some Trump officials too. Judge Doughty, if you recall, held in July that the government could be held liable for violating the free speech or the First Amendment rights of the plaintiffs, which were mainly the states, Missouri, Louisiana, and the scientists and the conservatives whose posts were censored by the platforms. In this case, it mainly referred to Facebook, Twitter, and YouTube. Now, the issue in the case wasn't actually whether the platforms could be held liable as state actors for censoring or suppressing the speech rights of these individuals. It was actually whether the government could be held liable for doing it. And this gets to the issue of whether it significantly encouraged or coerced the private actors to do what they did. Now, Judge Doughty ruled that based upon 155 pages of evidence that he included in his opinion. Of course, there were actually thousands of pages of depositions and such, and emails that were produced during discovery that showed the very tight, close-knit coordination between the government officials. And again, there were dozens of government officials and the tech company employees that they held regular meetings. The government officials flagged specific posts, and a lot of this stuff had to do with COVID vaccines. But there was also some FBI and whatever they deemed to be misinformation, including the Hunter laptop story, right? That they flagged these posts that they considered problematic and asked the tech companies to either, suppress them, to reduce this so they wouldn't appear in as many people's feeds, or to remove them entirely, and in some cases to actually boot the people who were making them, like Alex Berenson. And the judge here ruled the government officials crossed the line, the First Amendment line, and the Fifth Circuit largely upheld the lower court Judge Doughty's opinion. It went even further in some ways and really kind of distilling the case law and the precedents for its opinions. So it actually spent less time on the facts of the case than Judge Doughty did, but it spent more on actually reviewing the case law and kind of spooling out why it is, based on the circuit court and Supreme Court precedents, why the government violated the First Amendment rights of the plaintiffs. Now, it narrowed Judge Doughty's injunction, which basically was, in the Fifth Circuit's words, vague and overbroad. And the way he narrowed it, or they threw out apparently, I think, 9 of the 10 points in the injunction, and actually narrowed the last ones to permit the government officials to continue to communicate with the tech platforms as long as they weren't actually exerting any coercive pressure. Because being able to communicate, that is essentially the speech right of the government officials. So that's where the Fifth Circuit actually dramatically narrowed the injunction, and also kind of threw out the complaints against Anthony Fauci by some scientists who complained that he was kind of working with the social media companies to suppress the Great Barrington Declaration. The Fifth Circuit actually didn't find any evidence that they were actually having direct coordination or direct meetings or anything like that. Anthony Fauci, it was more of a public campaign to pressure the government officials or to essentially discredit the Great Barrington Declaration to induce the companies then to take it down, but there wasn't actually any direct coordination there.
The challenge in this case, Kim, to my eye, has always been that the plaintiffs are bringing evidence that includes a whole spectrum of activity. And on one end is stuff like public health officials flagging things to Facebook and saying, we're seeing all of these claims that COVID vaccines, for example, contain microchips, that they can have these side effects. Can you confirm to us whether there's any truth to these claims or not? Similar sort of things happening in the election space, agencies flagging things that they were seeing and saying you might want to take a look at this. On the other end are emails from pretty senior White House officials asking platforms to look at something ASAP, giving what kind of sound like orders, and then these social sites responding in a very solicitous manner. And so I do think it's interesting the detailed level with which this appeals court is parsing this. I'll just read a piece of the ruling. It says, we find the district court did not err in determining that several officials, namely the White House, the Surgeon General, the CDC, and the FBI, likely coerced or significantly encouraged social media platforms to moderate content, rendering those decisions state actions. In doing so, the officials likely violated the First Amendment. But we emphasize the limited reach of our decision today. We do not uphold the injunction against all the officials named in the complaint. Indeed, many of those officials were permissibly exercising government speech, carrying out responsibilities, or merely engaging in a legitimate action. And so, Kim, there's all sorts of focus on this coercion test. It brings up a test that has been used in the Second Circuit, asking judges to look at the tone that officials use, the perception of that tone, whether there's any adverse consequences that the officials are citing. And so it looks to me like a pretty fact-bound analysis. And remember the posture here, we're up on an appeal of a preliminary injunction. So I guess this goes back down and you may end up having a trial where you may get testimony on those questions about whether this was real coercion by the government.
I mean, this is the crux of the decision and why it was so important that the court spent so much time on the detail and giving examples, because this is not just some rant about government behavior. It's trying to draw very specific distinctions between what is allowable and what is clearly not allowable. And that list of actions, Kyle, I mean, it was extremely long. They were flagging different posts they didn't like. They were monitoring posts. They were demanding data from the social platforms, then responding to that. They were attending regular meetings. And so that's the side. There was also threats clearly issued, and the court laid those out too. White House Press Secretary Jen Psaki saying that the White House expects more from the platforms. The Surgeon General speaking at a press conference saying that the platforms were one of the big obstacles to controlling COVID. The president himself, President Biden, saying that platforms were killing people. All of these could certainly be viewed as threats of some sort of action if these companies didn't do what they were being asked. The companies clearly saw it that way. And that's the other important part of the ruling, is not just pointing out what the officials did, but what was done in response. That certainly demonstrated the companies themselves felt that they had to respond. And all of this is very different, for instance, to what the court said might be allowable, which is for the administration to issue a very wide alert saying, be on the lookout for these things, please. We're kind of concerned about this. But the interaction, the orders, the demands, the threats, those were very clear examples the court's laying out of where this goes beyond social media companies making their own decisions and instead feel as though they must act as an arm of the government.
Alicia, where do you think this is going in the end? Is there likely an appeal to the Supreme Court here? To my eye, these kind of social platforms, these sites like Facebook and Twitter are still new enough that we don't have a whole lot of great precedent about how these traditional tests of coercion, for example, are going to be applying to them. And so is this a real opportunity for the Supreme Court to set down some markers for the judiciary?
So I think it's interesting is the Fifth Circuit clearly teed up an appeal to the High Court, or maybe it was presuming that the Biden administration might appeal because it included a note in its decision that the government coercion and collusion with these private actors was essentially unprecedented in the case history. And to your point that, again, that the Supreme Court hasn't considered a case anywhere even remotely similar to this one, even though it has considered in the past. I think one of the case precedents that the Fifth Circuit leaned on was the Blum 1982 precedent that helped set forth this significant encouragement in coercion test, or what the Fifth Circuit called the close nexus test, in that the government officials must have something more than uninvolved oversight over these platforms. And that the Blum case actually involved nursing homes and Medicaid program, and whether the state could be held responsible for physician decisions. And in that case, the Supreme Court held that it cannot be because physicians were still making these decisions independently. So this case involving the tech platforms and essentially collusion between government and the tech companies really doesn't have a close parallel. Now, Justice Thomas has a number of opinions almost inviting plaintiffs, whether it be states or other private plaintiffs, to tee up more cases involving the tech platforms because they are percolating in lower courts so that the Supreme Court can address these kind of more thorny issues. And though I'm kind of struggling to project exactly how the Supreme Court ruling would affect other cases, because again, this is unprecedented. And the fact that the tech companies were responding to direct government pressure, and whether the Fifth Circuit ruling and its injunction may actually just head off that kind of future coordination and inclusion itself, and averting the need for the Supreme Court to weigh in. And I think the court generally does like to avoid kind of politically contentious issues, but I think there's also some disgust among some justices by how the government acted during the pandemic in general, these kind of emergency measures, but also this kind of using private actors to do what they cannot do legally. And all this behind the scenes, the emails, it really is quite disgusting and reprehensible. And I think some justices maybe want to just rein in government and say, no, you cannot do this, even if a similar situation might not occur again, and just slap the government officials down.